Hello and welcome to this video blog. I am attorney Greg Smith and I've been practicing law for going on 25 years in Salt Lake County, Utah. However, we cover the entire state of Utah, so feel free to give us a call. This is not legal advice, and if you have an issue, please contact an attorney as soon as possible. Today we're going to talk about your rights under federal law, your rights under state law, and we're also going to talk about what wrongful termination means, what you can sue for and what you can't sue for. You know, about 3 or 4 times a day, I'll pick up the phone and I'll have a very upset employee. And oftentimes they'll start talking a million miles a minute and they'll go off on this rant. And then when they finally catch their breath, they'll say, "Can they do that?" So we're going to find out today what the employer can do and what the employer cannot do. Again, this isn't legal advice, and call an attorney ASAP because there are statutes of limitations and there are other things that you must comply with. And if you don't, your case can be forfeited no matter how good it may be on the merits. So let's get right down to it. Okay, let's start off here by going to the United States Equal Employment Opportunity Commission, better known as the EEOC. Now, most people know what their rights are. You know that the boss can't just fire you because you're a certain color or you were born in a certain country or because you're a male or a female or because of your religion or your race. Most people know that. Those laws have been around since 1964. But what a lot of people don't know is this, and this is what's in the box. The anti-discrimination laws give you a limited amount of time to file the charge of discrimination. In general, you need to file a charge within 180 calendar days from the day the discrimination took place. Now, did you catch the fine print below that square? If you're a federal employee, you need to move on things within 45 days. So go back and take a quick look at that. That's the kind of time crunch that you're under. Now that's a lot of legal gobbledygook, isn't it? Just make sure that if you feel you have been discriminated against, you call an attorney immediately. And if you do not file timely, you forfeit your case. So that's the number one thing. In Utah, we have something called the UALD, Utah Anti-Discrimination Labor Division. And we don't have an EEOC in Utah. So what I would encourage you to do, if you don't make that call to an attorney immediately, call the UALD. They're downtown Salt Lake City, Utah, I believe 160 East 300 South, 160 East, I believe it is, in the Heber G. Wells building. But you got to get there. You can also file stuff online, but do not miss this or you lose. So let's go to the next one. This is an example of what a boss cannot fire you for under state law. We just covered federal law. Now let's cover state law. So it says here, an employer may not deprive an employee of employment, threaten, or take any adverse employment action or otherwise coerce the employee regarding employment because the employee receives a summons, responds to it, serves as a juror or a grand juror, or attends court for prospective jury or grand jury service. So if you're on jury duty, the boss can't, get in your way. And if he does, the boss can actually be guilty of criminal contempt and could also be fined as much as $500 or imprisoned not more than 6 months. But most people who call me are more interested in number 4. Now, if your boss fires you for jury duty, you can sue the boss. But notice what this says. Bring your action within 30 days. 30 days. Seriously, Utah legislature? Seriously, 30 days. I'm talking to you, Mr. Congressman, Mrs. Congresswoman. I'm talking to you. But are you kidding me? 30 days? I hope that the person watching this video is outraged because I am. Can you feel it? Let's move on. Alrighty. And of course you can sue for lost wages, and it limits how many days you can get lost wages for. And I don't know why the Utah legislature decided to limit your rights to such a few short days and such a small recovery. But hey, it does provide for attorney's fees, which means you can probably find an attorney. A lot of times you can go to an attorney and say, hey, I was wrongfully terminated by my boss and I got a new job, 3 weeks later, but I was out 3 weeks of pay. The attorney can sue for that. But the problem is, unless there's a contract for attorney's fees or unless there's a statute for attorney's fees, an attorney may not take your case, because if you don't have the money to pay him, $200, $300, $400, $500 an hour, he may not be interested in spending 100 hours on a case to help you, when ultimately he's not going to be able to get paid. So it's kind of tough. So you need to ask your attorney if there is an attorney's fees provision for what happened against you, because if there is, the attorney is going to be much more likely to take your case. Now, the federal violations, typically, attorney's fees will be awarded if you win. But wrongful termination under a state statute is considered a tort. And unless you have a written contract by your employer, or unless there's a statute saying you can get attorney's fees, chances are you will not get attorney's fees. But there's an exception to this. It's called the HESLOP exception. If your boss did not follow procedures that the company promised you when it came to your termination, and they just summarily dismissed you, they just fired you without going through those promised procedures, then you may be able to get attorney's fees. And your attorney may not be aware of the HESLOP rule. Just remember this. Ask your attorney to look up the HESLOP case, and ask your attorney to look up the United States case of Freres, F-R-E-R-E-S, that talks about the HESLOP case. I know, way too much information, right? Now, here we go to the Walmart case. And the Walmart case was recently decided by the Utah Supreme Court. Here it is, Supreme Court of Utah right there. And by the way, this little number up here, if you want to go to a law library and you want to tell the law librarian, that you need a case, you give them that number and they can look it up in the proper book for you or online. So this is the Ray versus Walmart stores case. Let's assume there's a policy. A company has a policy that says, hey, you cannot get into a physical altercation with our customers no matter what. Well, let's assume you work in loss prevention and you catch somebody stealing something and they get mad and they pull a knife, or you're in a corner and they pull a gun. Now you're cornered. You can't escape. You cannot escape. And you think they're going to inflict imminent, which means right now. You think that right now they're going to inflict imminent serious bodily injury upon you, cut you, shoot you with a bullet, what have you, or even death. So the question is, can you fight back? Can you defend yourself? This went to the Utah Supreme Court, and the Utah Supreme Court said, listen, there are certain public policies that say you cannot fire an employee for doing certain things. For example, if an employee walks into your office, into the boss's office, and says, I've been working 50 hours a week, I'm flipping burgers for you, you're supposed to pay me overtime for all hours I work beyond 40. And the boss says, you're fired, you're a troublemaker. Well, that's retaliation. And you cannot fire somebody because they're asserting a right that the legislature, in this case, the United States Fair Labor Standards Act, has been a law since, I believe, 1936, if I recall. And, Republicans and Democrats have honored that law through different Democratic and Republican administrations since, like I said, the late 1930s. So your boss just can't, it would be against public policy to fire you for saying, hey, you need to pay me overtime. Goodness gracious, I'm not even making a minimum wage. You put me on salary. You're working me 70 hours a week and you're only paying me, $200 a week. I'm not even making a minimum wage. And even if you end up being wrong, if you go to your boss and you think you're not being paid properly and you end up being wrong, and he doesn't owe you more minimum wage and he doesn't owe you more overtime, but he retaliates against you, you can still sue and you can still get a recovery. So this went to the Utah Supreme Court, and the Utah Supreme Court said this is a case of what was called first impression. And what first impression means is that it hasn't come before the court before. So the court's like, that's a good question. So if you're in a corner and you're facing imminent, substantial, significant bodily injury or death, can you fight your way out of it? Can you defend yourself? Or if you do that, does the boss have a right to fire you because you defended yourself? And the Supreme Court said, you know what? In our Constitution, you have a right to defend yourself. And so here's what the court said. Even though you're an at-will employee, which means the boss can normally fire you at any time for any reason, there's an exception to that. He says an at-will employee may sue, in other words, may maintain a wrongful termination claim, may sue the boss for wrongful termination if the employee was fired, ready, for engaging in self-defense. But they put a restriction on it. But only if that employee faced an immediate, imminent threat of serious bodily harm, broken bones, getting stabbed, that kind of thing, under circumstances where the employee was unable to safely withdraw. But if you're in a corner, you cannot escape, can you fight your way out of it and defend yourself? The court said yes. So this is probably the most important part right here. It says under the at-will employment doctrine, and again, at-will means the employee can quit for any reason at any time, and the boss can fire the employee at any reason, for any reason at any time. Under the at-will employment doctrine, an employer has broad discretion to manage its workforce and may, accordingly, fire an employee for any reason not prohibited by law. But there are several exceptions to at-will employment, including when an employee's termination violates a clear and substantial public policy of the state. Now, they've gone on to say, for example, if you file a workman's compensation claim, the boss can't just fire you for that because his premium went up. If, for example, if you blow the whistle on something, you know the boss is absolutely cheating on his taxes, so you call the IRS to tell them, the boss finds out and he fires you. That would be also a wrongful termination. So the boss can't fire you for exercising a clear, substantial legal right. Thank you so much for watching this video blog. And remember, if you have an employment issue, call a qualified employment lawyer immediately. Have a terrific day.